next case is State versus Rust. Each party will have 15 minutes to present their argument. Of course, you're the only person here, so you just have your 15 minutes in total without any rebuttal time. The arguments are being recorded. When you start, please introduce yourself for the record. Make sure you stay behind the podium and you speak up so we can hear you when the recording can pick you up as well. If you move from the podium, we'll do too, so we appreciate you staying there. To the extent you're going to refer to any victims in this case, please use initials or some other terms such as the victims or neighbors, whatever term you feel like using in this particular case. We've read your brief and are ready to proceed whenever you are.
Thank you, Judge Stevenson. Your honors, and may it please the court, Andrew Karras, Summit Legal Defenders on behalf of Appellant Ralph Rust. There are two questions we've raised in this case. The first, perhaps principal question is, are wooden stakes boundary markers or monuments within the meaning of the criminal mischief statute? I submit that the answer is that they are not, and we ask that this court reverse the conviction below for want of sufficient evidence. We have also raised the hearsay issue, specifically was the principal of the surveying company that performed the work in this case, was his statement to the investigating officer that the work was, quote, very accurate, improperly admitted. I submit that it was, and we'd ask for a reversal on that ground in the alternative. I'll address these issues in order. Obviously, I'm happy to field any questions as they come up, but to start with our sufficiency issue. Criminal mischief, Revised Code 2909.07, subsection A3, prohibits a defendant from tampering with a, quote, benchmark, triangulation station, boundary marker, or other survey station, monument, or marker. In finding that Rust was guilty of the offense below, the trial court relied on the residual provision of that, specifically that the stakes at issue in this case were, quote, an other survey station, monument, or marker. In thinking through whether that was an appropriate invocation of that residual provision, I think there are a few rules of construction to keep in mind. First, as we've cited in our brief, the rule of lenity, Revised Code 2901.04. This is a statute that defines criminal conduct, and so it should be construed strictly against the state and in favor of the accused. Also, just the general canons of statutory construction that the General Assembly has enacted, Revised Code 1.42, says that words with technical meanings should be understood according to those technical meanings. And here, the Engineers and Surveyors Board has promulgated regulations specifically defining what is a monument in the practice of surveying. Such with boundary monuments or reference monuments are supposed to be composed of durable material. There are minimum.
The statute doesn't just say monuments, though, does it? It says survey equipment. It says marker, monument, and other things. So
Certainly.
So wouldn't that encompass a broad amount of things a certified surveyor would use?
So I think what the statute speaks to is, so it starts with certain specifically articulated items. They're not, they don't all use the word monumentation, to your point. The specifically enumerated items are benchmark, triangulation station, and boundary marker. And what all of those share in common are they are placements used in the practice of surveying that have some indicia of permanence. So
isn't this not a question of law, but rather a question of fact, of whether the facts presented in this case constitute one of these words in the statute?
So we framed it as a sufficiency argument, and I think it does present a question of law that, and would adjusting some of the facts, adjust the legal analysis? I think yes. I mean, would it be a different question if they were wooden stakes, but it was impractical for some reason to use metal? I think the regulation contemplates that that can occur. Maybe that's a different legal question. If they were metal pins that otherwise didn't meet the Engineers and Surveyors Board for some reason, would that present a different legal question? I think yes, but I do think it is a legal question rather than a factual question. Again, to reiterate what I was speaking to previously, there is the specifically enumerated categories: benchmark, triangulation station, boundary markers, and then a residual category, an other survey station, an other monument, an other marker. And as we've laid in our brief, I would submit that the specific categories affect how that residual category should be understood. Again, these are by nature, they're permanent placements. We've relied on the 5th District's Ross case in our brief for support for that. In that case, there were stakes very much like the ones at issue here.
But in the 5th District case, was the person who placed the stakes a surveyor?
So the answer is yes, a surveyor assisted by somebody working for the timbering company.
So doesn't that make that distinguishable here, that it wasn't a certified surveyor who actually placed the stakes?
So if I could quote from the opinion, just momentarily, the employee of the timbering company, I think, according to the record, assisted the surveyor by holding the mirrored instrument. So he certainly helped. I don't know that it's clear on the record who specifically placed the stakes. And I think in a typical survey, the person placing the stakes may or may not be the principal of the company, who may or may not be a registered engineer or surveyor. I think, what drives the analysis is, why they are engaged in the particular project to define where the boundary is, and whether the work is ultimately supervised by somebody who is registered is, I think, what should drive the analysis. And to that point, there was the trial court distinguished Ross by saying, well, this wasn't, in Ross there wasn't a quote-unquote complete survey done. I think that's a distinction without a difference. I think the engineers and surveyors boards apply with equal force to partial and complete surveys. And maybe more to the point, if you look at the purpose of the survey work, partial, complete, whatever it was in Ross, it was very similar to here. So in Ross, they were defining where the line was so as to understand which trees were supposed to be timbered and which weren't. Likewise here, they were establishing the line to know where they should place a fence. There was no longer range surveying purpose that these stakes were being placed for. The balance of the testimony is that they weren't supposed to stay there forever. They wanted to understand where the line was so they could place the fence on their own property. And so, for that reason, I would argue that the stakes at issue in this case are very much like the stakes at issue in Ross.
Are there any 9th District cases on point?
Not to my understanding, Your Honor.
So the 5th District is the only one we have?
Yes, so we've also cited in our brief to, it's not an opinion, it is a quote-unquote order. So I think it's just persuasive only. But another case that discusses subsection A3, criminal mischief. That case, I think it's illustratively useful because it did involve metal pins. And there, my recollection, it was the 1st District in Hamilton County that said, in that instance, there are sufficiently permanent stakes to qualify as markers and monuments within the meaning of the statute.
And you get that from the administrative code, I think. That's what we're also looking at, eventually, the Ohio administrative code to define what those markers were.
Correct. And again, I think that's an appropriate understanding because what is a monument, what is a marker? I think that's a technical word that has a technical meaning, and we should rely on what the technical experts, that is the Engineers and Surveyors Board, have promulgated regulations to tell us.
But if you look to me at just what the point of the statute is we want people to know where the boundary markers are for each of the property. Clearly, you had someone to put some markers down there to make sure we knew where the boundary markers were. And it seemed to me that the defendant in this case didn't like where that was to pick them up and move them. And wouldn't that satisfy what the whole statute is concerned about, that we can safely place items in property where they're supposed to be?
So I think the statute actually speaks to a narrower social harm because it uses, like I've suggested, language suggesting that the things we're talking about are permanent surveying placements. It is about
Well, never said permanent. It calls them boundary markers or a thing. The administrative code is where we get the permanency more so than the statute, so. But it said other survey markers. Clearly, these can be other survey markers. They're survey markers that someone put there. Whether they're permanent enough is a question. You would say they're not what intended under the statute.
So I do think that, an other surveyor marker is modified by, what is a benchmark triangulation station or boundary marker, such that we should understand those other markers as being things that are themselves also permanent. And I don't think that makes the residual category, useless or meaningless in any sense. We've cited, some materials from the United States Geologic Service in our brief that talk about, what kinds of survey markers, what kinds of placements do surveyors make out in the field. And there are other permanent objects that are surveying markers that aren't specifically benchmark triangulation stations and boundary markers.
So aren't we conflating monuments versus markers as well? I mean, the plain meaning of a marker might not be permanent, but maybe the plain meaning of monument or even in the administrative code could be permanent. I mean, when you're talking about that first district case, were they saying it was a marker or a monument? I mean, what was the analysis there?
What drove the analysis in the first district case was the fact that what was at issue where there were metal pins marking the property boundary line that were installed by a licensed professional surveyor and were intended to be permanent. That's the language from that order. So here I would say that we have.
So do they call that a monument under the statute?
I don't know that they specifically distinguish between is it a monument or is it a marker?
The different words of the statute.
Yeah, I don't know that they reach that particular point of statutory interpretation in that case. But I don't know that that's ultimately what drove the analysis. Again, I think it was, what drove the analysis are these placements intended to be permanent? Are they there for some longer range surveying purpose, or are they in aid of maybe like a short to medium term construction or net moving project? So unless there are further questions about that, I see that I
have 3 minutes. Yeah, about 3 minutes left.
So I'll just very quickly hit on some of the points we've made with respect to the hearsay issue. The court found that Wellert's statement to Deputy Remedio that the survey was, quote, very accurate, could come in because it helped explain Deputy Remedio's investigatory conduct. Looking at the risk factors we've cited in our brief, I don't think that necessarily is the case. I think the record establishes that Deputy Remedio could have and very well probably would have proceeded to go knock on Mr. Rust's door and interview him about his position on the case, irrespective of Mr. Wellert's description of his company's surveying work. And I would submit that it was prejudicial because it was the only competent evidence, the only that the boundary that the company established was in fact accurate. And because it was prejudicial in that sense, I would also submit that it wasn't harmless because, again, absent that evidence, I don't know that the state makes out the case that Rust acted, quote-unquote, without privilege. And so unless there are other questions, I'm happy to rest on my brief.
Seeing none, on behalf of the court, thank you for your presentation this morning. The court will take the matter under advisement and look at the decision in due course. And that decision is related to be mailed to you by the clerk of court and also be posted on the High Supreme Court website.
Thank you, Your Honor.